Major Supreme Court ruling on New York's concealed carry regulations.
That law has been in place since 1913.
The right to keep and bear arms shall not be infringed.
There's a legal document filed by the Department of Justice that has state attorneys general in California, New York, and New Jersey frantically calling emergency meetings with their legal teams. It's not about immigration. It's not about taxes or regulations. It's about guns. And the legal strategy being deployed is so unprecedented that constitutional scholars are calling it the most significant Second Amendment case since the Supreme Court's Heller decision. Here's what makes this genuinely explosive. The Trump administration just did something no previous administration has ever attempted. They're using civil rights discrimination laws, the same legal framework that broke up discriminatory police departments and protected voting rights in the 1960s, to go after states that systematically deny gun permits. The Department of Justice filed a federal lawsuit arguing that making someone wait years for a constitutionally protected right while charging them thousands of dollars in repeated fees is no different than the poll taxes that were ruled unconstitutional when southern states used them to prevent Black Americans from voting. And the numbers backing up this lawsuit are so outrageous they sound fabricated. Between January 2024 and March 2025, Los Angeles County received 3,982 applications for concealed carry permits. Want to guess how many they approved? The answer is going to make your jaw drop. But here's why this matters beyond just California. If the DOJ wins this case, and legal experts say they have an exceptionally strong chance, it creates binding legal precedent that makes these delay tactics illegal everywhere. New York, New Jersey, Maryland, Hawaii, Massachusetts, Connecticut, every state that's been playing bureaucratic games with Second Amendment rights suddenly becomes vulnerable to identical lawsuits. This isn't just about fixing one county's permit process. This is about whether states can functionally ban constitutional rights through bureaucratic obstruction. And the answer to that question is about to reshape gun laws across America. The approval rate, worse than Harvard. Let's talk about statistics that seem impossible until you see the actual data. Harvard University's acceptance rate hovers around 3.4%. Stanford sits at approximately 3.7%. These are considered the most selective institutions in America, places where brilliant students with perfect grades and extraordinary achievements get rejected routinely. Now, back to those Los Angeles County concealed carry permit applications. Between January 2024 and March 2025, the county received 3,982 applications from law-abiding citizens seeking to exercise their constitutional right to bear arms. The number of permits approved? 2, not 200, not 2 dozen. 2 individual permits out of nearly 4,000 applications. That's an approval rate of 0.05%, making it literally more selective than the most elite universities on the planet. Citizens actually have a statistically better chance of being struck by lightning twice than receiving approval for a concealed carry permit in Los Angeles County. But the numbers get even more absurd when examining wait times. Some applicants have been waiting over 1,200 days. That's more than 3 full years, just to receive any response at all. Not approval or denial, just acknowledgement that their application exists. Here's the part that transforms this from bureaucratic incompetence into potential constitutional violation. California has state laws explicitly designed to prevent exactly this situation. The state penal code clearly mandates that initial determinations must be made within 90 days, and final approval or denial must occur within 120 days maximum. Los Angeles County isn't slightly exceeding these timelines. They're ignoring them entirely by years, while continuing to accept applications and fees from citizens who have no realistic chance of approval. The financial penalty for exercising rights. There's a hidden cost to these endless delays that most people never consider, but it's quietly draining thousands of dollars from applicants who are simply trying to comply with the law. When California forces applicants to wait years for permit decisions, it's not just wasting time, it's creating a cascading financial burden that functions as an unconstitutional tax on rights. Here's how the scheme works in practice. Every time an application expires during the interminable waiting period, applicants must pay renewal fees to keep their application active. Every time training certifications become outdated while waiting, applicants must pay to retake courses, sometimes multiple times. Background check fees, fingerprinting fees, processing fees, all must be paid repeatedly as bureaucrats drag their feet. Some California applicants have documented spending over $2,500 attempting to navigate this process, and after years of payments, they still don't possess the permits they're constitutionally entitled to receive. This creates what legal scholars are calling a poll tax on constitutional rights, and that's not rhetorical flourish. Poll taxes are the exact same concept that was ruled unconstitutional when southern states tried charging citizens to vote, deliberately creating financial barriers to exercising fundamental rights. The average applicant spends between $800 and $1,200 over the course of their wait time, paying for renewals and recertifications that would be completely unnecessary if the county simply processed applications within the legally mandated timeframes. This isn't accidental, it's a feature, not a bug. A way to make exercising Second Amendment rights so financially burdensome that many citizens simply give up rather than continue paying indefinitely. The legal strategy nobody saw coming. Here's where Trump's Department of Justice did something genuinely unprecedented that has constitutional law professors scrambling to update their textbooks. They're deploying 34 U.S. Code Section 12601, a civil rights law originally created in the 1960s to dismantle corrupt police departments that violated citizens' constitutional protections. This is the same legal framework used to break up discriminatory law enforcement practices, the same statute that protected voting rights from state interference. And now, for the first time in American history, it's being wielded to protect Second Amendment rights from state obstruction. The legal theory is straightforward but revolutionary. If denying someone their constitutional rights through systematic discrimination is illegal for voting, speech, or religion, then it's equally illegal for firearms. When the federal government treats gun rights as civil rights under the same legal protections, the entire framework for litigation changes fundamentally. States can no longer hide behind claims of public safety or reasonable regulation when the evidence shows systematic denial of constitutional rights. Just as southern states couldn't justify poll taxes by claiming they needed revenue, California can't justify 1,000-day delays by claiming they need time to process paperwork. The constitutional violation isn't about the stated justification, it's about the systematic denial of rights through procedural obstruction. The administrations that knew and did nothing. Here's the part that should make citizens genuinely angry. This pattern of systematic rights denial isn't new information. Previous administrations knew exactly what was happening and chose not to act. Internal Department of Justice memos from the Obama administration show they were aware of excessive wait times in multiple California counties as far back as 2014. They possessed the data, they received the complaints, they had the legal authority to intervene, and they deliberately chose to look the other way. Why? Because filing civil rights lawsuits against blue states over Second Amendment violations wasn't politically convenient or advantageous. The DOJ under Obama and Biden would immediately spring into action for other categories of civil rights cases. They'd investigate police departments for excessive force. They'd sue states over voting access restrictions. They'd file amicus briefs in discrimination cases involving protected classes. But when it came to the Second Amendment, suddenly those same enforcement mechanisms became unavailable. The DOJ would only reluctantly get involved if cases were already advancing through federal courts. And even in those situations, they frequently filed briefs opposing gun rights rather than defending them. The Obama administration's DOJ actively defended the District of Columbia's handgun ban in court. The Biden administration defended numerous state-level gun restrictions. For over a decade, law-abiding gun owners were left fighting expensive legal battles alone against states with unlimited taxpayer-funded legal resources and no accountability for violating constitutional rights. During those years of deliberate federal inaction, thousands upon thousands of permit applications were improperly denied or indefinitely delayed. Citizens were deprived of their ability to defend themselves and their families, all while federal officials who swore oaths to defend the Constitution chose political expediency over constitutional duty, the precedent that threatens every restrictive state. This is the genuinely game-changing aspect that will ripple across every jurisdiction with restrictive gun laws. If Trump's DOJ prevails in this lawsuit, and legal analysts say they possess an exceptionally strong case, the victory doesn't merely fix California's broken permit system. It establishes binding legal precedent that makes these bureaucratic delay tactics illegal nationwide. New York, New Jersey, Maryland, Hawaii, Massachusetts, Connecticut, and any other state that's been playing procedural games with Second Amendment rights will immediately be on legal notice. Any jurisdiction maintaining wait times that exceed reasonable periods becomes vulnerable. Any county with suspiciously low approval rates that can't be justified by legitimate safety concerns becomes a target. Any state using red tape and bureaucratic complexity to functionally ban gun ownership faces potential federal civil rights litigation. Once a federal court rules that these delays constitute civil rights violations under the same framework that protects voting and other fundamental rights, the implications extend far beyond just concealed carry permits. The precedent applies to any gun-related licensing, registration, or approval scheme that creates unreasonable barriers to exercising constitutional rights. Purchase permits that take months to process, registration systems that require extensive paperwork and fees, training requirements that are only offered once per year in limited locations. All of these become challengeable under the identical legal theory if they systematically prevent citizens from exercising their rights. The financial risk alone will force states to reconsider their approaches. Civil rights violation cases come with substantial financial penalties, mandatory legal fee payments to prevailing plaintiffs, and potential ongoing federal monitoring. Even jurisdictions that aren't directly sued will likely begin reforming their processes proactively just to avoid becoming the next target. Blue state attorneys general are already having uncomfortable conversations about their vulnerability if this precedent gets established. The constitutional framework that changes everything. What makes this lawsuit particularly powerful is how it reframes the entire Second Amendment debate by placing gun rights within the same constitutional framework as other fundamental liberties. For decades, gun control advocates have successfully argued that firearm rights are somehow different, that they can be regulated, restricted, and burdened in ways that would never be tolerated for speech, religion, or voting. This legal strategy destroys that artificial distinction. If making someone wait 3 years and pay thousands of dollars in repeated fees to exercise their Second Amendment rights is constitutional, then the same burdens could theoretically be applied to other rights. Imagine if citizens had to wait 1,200 days to receive approval to vote, with applications expiring and requiring new fees every few months. Imagine if practicing religion required government permits with 0.05% approval rates. Imagine if exercising free speech required paying $2,500 in certification and recertification fees over 3 years before receiving government permission to speak. The absurdity becomes immediately obvious when the same standards get applied to rights that enjoy broader political support. But constitutional rights don't exist on a hierarchy where some get robust protection while others can be systematically obstructed. They're all fundamental liberties guaranteed by the Constitution, and they all deserve equal protection from government interference and discrimination. So here's where this unprecedented legal battle stands. Trump's Department of Justice just deployed civil rights discrimination laws in a way that's never been attempted in American history, using the same legal framework that protected voting rights and dismantled discriminatory police practices to go after states that systematically deny Second Amendment rights through bureaucratic obstruction. The numbers are undeniable. Los Angeles County approved 2 permits out of nearly 4,000 applications, a rate more selective than Harvard, with wait times exceeding 3 years and costs surpassing $2,500 per applicant. California's own state laws mandate decisions within 120 days, yet the county ignores those requirements entirely, while continuing to collect fees from citizens who have virtually no chance of approval. Previous administrations knew about these systematic violations as far back as 2014 and chose not to act because prosecuting blue states over gun rights wasn't politically convenient. Meanwhile, those same administrations aggressively pursued other civil rights cases, revealing a selective enforcement approach that left Second Amendment protections as second-class rights. If the DOJ wins this case, it creates binding precedent that threatens every state with restrictive gun laws. The legal theory applies not just to concealed carry permits, but to any licensing, registration, or approval scheme that creates unreasonable barriers to constitutional rights. States will face the choice of reforming their systems voluntarily or risking expensive federal civil rights litigation they're likely to lose. This is what constitutional accountability looks like when political will finally aligns with legal authority. The question now is whether federal courts will affirm what the Constitution already guarantees, that fundamental rights cannot be systematically denied through bureaucratic schemes designed to make exercise of those rights practically impossible. The answer will reshape gun laws across America for generations.